Okay, we're going to go ahead and get started. Good evening, everybody. Welcome to our Future of Funding for Religious Schools panel. My name is Chloe Knox, and I'm the Vice President for Speakers for UVA's Federalist Society chapter. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Tonight, we're joined by Professors Micah Schwartzman, Stephanie Barclay, and Nathan Chapman. Professor Schwartzman is a director of the Karsh Center for Law and Democracy at UVA and teaches courses in law and religion, political philosophy, and constitutional law. He is a graduate of UVA Law and received his doctorate in politics from the University of Oxford, where he studied as a Rhodes Scholar. He served as an articles development editor of the Virginia Law Review and clerked on the Fourth Circuit. Professor Schwartzman co-edited The Rise of Corporate Religious Liberty and is co-authoring a forthcoming casebook on constitutional law and religion. Professor Stephanie Barclay is a professor at Notre Dame Law School, where she teaches courses on religious liberty and family law. She graduated summa cum laude from BYU Law School, where she began her time as a professor. Before beginning her career in academia, she litigated First Amendment cases at the Becket Fund for Religious Liberty. Professor Barclay clerked on the Ninth Circuit and will clerk for Justice Neil Gorsuch on the Supreme Court next year. Professor Nathan Chapman teaches courses in constitutional law, procedure, and ethics at the University of Georgia School of Law. He received his JD and Master's in Theology from Duke University. After graduation, he clerked on the 11th Circuit and litigated in Wilmer Hale's DC office. His scholarship focuses on the history of due process in law and religion. Thanks so much to our panelists for being here with us tonight. How the format of this evening will work is Professor Barclay will speak first, followed by Professor Schwartzman, and then we'll hear from Professor Chapman. As always, our audience members can submit questions throughout the event by using the Q&A feature at the bottom of your screen, and I will come back at the end to lead our Q&A portion. So again, feel free to submit those throughout, and also if you feel so brave, you can raise your hand during the Q&A portion and I will unmute you so you can ask your question aloud. And with that, Professor Barclay, I'm going to turn it over to you.
Thank you, Chloe. Thanks for that invitation, and thank you to the Federalist Society for having us. And it's great to be here with Professor Chapman and Professor Schwartzman. I'll just start by giving a brief overview about the Supreme Court's decision and some of the facts at issue in the Espinoza case from this last term, and talk about some possible arguments at issue and implications from this case. In 2015, the state legislature in Montana created a tax credit program, a scholarship program, which allowed a tax credit of up to $150 of contributions to privately run scholarship programs. And these could go to any private schools, including religious schools, the way that the program was initially created. But shortly after this program was created, the Montana Department of Revenue promulgated what was called Rule Number 1, and that administrative rule prohibited families from using this scholarship money at religious schools. In an ensuing lawsuit, the Montana Supreme Court struck down the entire program, and it cited the state's no aid provision as the reason for striking down this program. This no aid provision is also known as a Blaine Amendment, and we'll talk about that a little bit more later. But what the provision said, this is part of Montana's constitution, is, quote, the legislature, counties, cities, towns, school districts, and public corporations shall not make any direct or indirect appropriation or payment from any public fund or monies, and goes through a lot of different examples, in whole or in part, by any church, sect, or denomination. So it's saying public money can't go to these sorts of groups. So the Supreme Court addressed in this case basically how the issue was going to come out now where we were dealing with a question of religious schools, an issue that the court had reserved in its previous ruling in a case called Trinity Lutheran, where it dealt with public aid to preschools dealing with surface areas for their playgrounds. The court's holding in this case was that Montana's no aid provision discriminates based on religious status. Importantly, the court said that a state need not subsidize private education, but once the state decides to do so, it can't disqualify some private schools solely because they're religious. In other words, religious schools aren't entitled to get public funding no matter what, but if the government's handing it out, then it has to do so in an even-handed way. There is an interesting argument and just sort of a question about how much this distinction between status and use is going to continue to matter moving forward. It's something that the chief relied on in his majority opinion, and he did sort of caveat that he need not decide in this case whether or not that status use distinction is critical or not, because here there was such a distinction, and so that was enough to subject this rule to strict scrutiny, and the government wasn't able to meet its very high burden under strict scrutiny. One thing I'll talk about just really briefly is the question of how we should think about this ruling from the court. Is it a departure from what the Constitution should look like? It is certainly different from some previous precedent, or is it sort of going back to maybe a clear understanding of the original meaning and some of the historical practices relevant to how we should understand the Free Exercise Clause, the Establishment Clause? And I would argue that it's more of the latter. We do see in this case an interesting trajectory from the court's 1970s decision in Lemon that was really famous, where we prohibited aid going to religious churches because of concerns about things like entanglement and how that was going to decrease the wall of separation between church and state if government was providing aid. Then we moved from that prohibition to the court's case in Zalman, where the court said it was permissible for states to include private schools in public funding for programs like vouchers if they wanted to. And now we have Espinoza, which is very different from Lemon, and the court is saying it is required that if the government offers public funding, again, to a variety of groups that religious groups are comparable to, then it has to offer that funding in an even-handed way to religious groups as well. So what does history tell us about money going to private religious groups during the founding period? Well, Professor Chapman has written about a lot of examples with money that was given to missionary groups that were religious during the founding period. I'm sure if you may talk more about that. My friend Mark Storsley has written about a lot of examples of money that was given during the founding period to schools and other charitable organizations. And there's one example I talk about a little bit in a somewhat recent article of mine, where a critique of the established church in England was that the minority religious groups didn't have the ability to find a school where they could teach their own religious doctrines. The government had a monopoly on just having the doctrines of the established church teaching them, but the issue wasn't that, the concern wasn't that other groups might want to do that too. They were prohibited from doing so. So Professor Schwartzman has some really thoughtful scholarship about debates around the founding period regarding church taxes and what those debates might suggest for us. And I think it's probably worth discussing that a little bit more. But one argument that my colleague Mark Storsley has made is that church taxes are best understood as an example where our founders were worried about government requiring payment that looked like a specific religious observance, money that was earmarked for a specific religious purpose. And there was, a link between the money you were paying and the religious group it was going towards in a way that felt more like a tithe, a religious practice, as opposed to just money given into the general public pot that is then distributed out to groups, including religious groups, to do general good works like educating and providing charity. So what is the real history that has been relevant to this sort of no aid view of religion? I think the relevant history here is the anti-Catholic bigotry that was relevant to Blaine amendments. The first time we see the Supreme Court talking about limiting aid to religious groups, the justices are quoting a speech by President Grant that talks about how the dividing line in our country will be not between the Masons and the Dixons, but between patriotism and intelligence on the one side and superstition, ambition, and ignorance on the other. And that other side is referring to private Catholic schools. And it was this sort of hostile concern about letting Catholic groups have their own religious schools that motivated creating a lot of these Blaine amendments after a national Blaine amendment failed to try and restrict funding that went to these sectarian groups. It's complicated history. Some Blaine amendments came later, so it's not equally true of every single Blaine amendment. But that's roughly a piece of history that I think animates much of what's going on here. And I think that that history, thankfully, shouldn't be the driving force of how we understand our religion clauses. I think it's better to return to the founding era history and an understanding of public funding that is treating religious groups as an important part of our public space and of groups that offer important services and charitable works in partnership with the government to serve some of society's most vulnerable. And so aside from being more historically grounded, I think as a normative matter, there's a lot to be glad about when we invite more religious groups in to do more of that good work. And I will turn it over to my colleagues.
Great. So I think I'm next. Thank you, Professor Barclay. I'm also really glad to be here with you and with Professor Chapman. It's always great to talk with you about religious freedom and these important issues that have been before the court recently. I'm going to follow your comments by taking up some of these questions, historical questions. But I first want to step back from the question that's raised here. The framing question is funding of religious schools after Espinoza. And I think it helps to situate that question in the context of the 20th century's and now the 21st century's history of Establishment Clause jurisprudence. And I think we can do that by looking at three moments. And I just want to briefly sketch them out. And then I want to talk a little bit about what explains the shift over time in the doctrine across those moments. And then I want to come to one, I think, quite important objection to state funding of religious organizations that we ought to be concerned about and we ought to pay attention to as the doctrine under Trinity Lutheran and Espinoza takes hold in the Roberts Court. So that's my plan. Okay, so three moments. I think, starting in 1947 with the incorporation of the Establishment Clause, we have the rise of what is often in the literature called separationism, the idea that there should be a strict separation of church and state and that the state should never aid religion. Now, what counts as aid and under what circumstances were difficult questions from the very start. Already in Everson, there's a question about whether the state can fund busing to private schools, and the justices are divided. But there was wide agreement on the Everson court in the 1940s that something like a principle of separation of church and state was the proper understanding of the Establishment Clause. Now, that's obviously controversial, and there are deep disagreements about the original meaning and so on, but I just want to mark the moment. From about 1947 through 1985, so from Everson through Lemon v. Kurtzman, through some of the high watermark decisions for separationism, Grand Rapids against Ball and Aguilar in the mid-'80s, there is an interpretation of the Establishment Clause which opposes aid, especially to religious schools. Starting in the and there depends on how you periodize this, but there in the late 70s, certainly in the 80s already, you have some cases that begin to break down this consensus. But it's clear by the 90s, there is a different view among the conservatives on the Supreme Court, and there is a move toward a more permissible approach, which requires even-handedness or neutrality in state funding of religion, but provided that some requirements of neutrality are met, the court says, especially in its Zellman versus Harris decision, allowing for school vouchers, as long as the aid is distributed on neutral terms, it's permissible under the Establishment Clause. And so I think we get a new moment starting in the late 90s, certainly through the early 2000s, where we move from a no aid principle quite clearly to some kind of permissibility as long as there's neutral or even-handed funding. From Trinity Lutheran forward, I think from 2017 through the present, and it will be interesting to see what kind of duration this principle has, we've moved into, I think, a new period where it's not sufficient for states to have permission to grant aid to religious organizations and schools, but at least in some circumstances where states are providing some kind of widely available public benefit, they are required to include religious schools and other institutions as recipients for those benefits. So just these 3 periods, we've moved from no aid to aid is permissible to aid is required, at least when it's otherwise made publicly available. Those are, I think, our 3 movements in our Establishment Clause and free exercise jurisprudence. You can ask a broad historical question now, what explains this shift over time? And the Supreme Court in Espinoza gives one kind of answer to that question. It's also given by Justice Alito in his concurring opinion. And they do it by citing to an article by John Jeffries and Jim Ryan, who of course is the current president of the University of Virginia. They have an article called The Political History of the Establishment Clause, which if you haven't read, I strongly encourage you to read it. And not only because the Supreme Court cited it, but because it's a fabulous piece of scholarship. I don't agree with it in all parts, but it's an important, I think it's an important document, an important history of changes in Establishment Clause jurisprudence. What the court cites that article for is the claim that restrictions on school aid were motivated in large part by anti-Catholic bigotry, by Protestant animus against Catholics and Catholic institutions. And Justice Alito goes to great lengths to develop this argument in his concurring opinion. It's also been expressed by other justices, notably Justice Thomas in an older decision, Mitchell against Helms, in a plurality decision there. This has become, I think, a deep feature of the jurisprudence among the conservatives on the court. Interestingly, though, the conservatives, the chief in the majority opinion in Espinoza and Alito, who cites the Jeffries and Ryan articles separately, they don't talk about another part of that history. Ryan and Jeffries talk about anti-Catholic bigotry, but they also go on to explain the realignment of Protestants and Catholics behind state funding of religious institutions in the 20th century, especially post-Brown, that is after desegregation and during efforts to integrate public schools. And that history is very important in the Ryan and Jeffries story. And the reason it's important is because there is political support that moves behind state funding of religious schools, in part because of massive resistance to desegregation after Brown. That is, the rise of white Protestant academies leads Protestants to want public support for private institutions. That makes them more sympathetic to positions that had earlier been occupied often by Catholics in support of their private institutions. One part of this complicated history then is that white supremacy and an interest in promoting segregation leads to a political realignment that supports public funding of religious institutions. That's a disturbing history, and the Supreme Court isn't telling any of it. And I mention it because I think there's disturbing history all over this discussion. And if we're going to have a historical debate about this, I think we ought to have a more complete picture of why the doctrine has shifted over time. I want to add this point to that history, which is I'm not saying, and I want to be super clear about this, that the only reasons for political support today or for a realignment of the courts in favor of public funding of religion has to do with white supremacy or the legacy of Brown. I don't think that's the case. I think there are powerful reasons to support state funding of religion, even if I don't, at the end of the day, agree with all of them. But I also want to say this, which is it's not the case that only anti-Catholicism supports separation and arguments against public funding or in favor of some kind of public separation where the state is restricted from giving money to religious organizations. There's animus throughout this history, but there are also, I think, perfectly reasonable and plausible grounds for very different views on state funding. Okay, my last point is just this. One of the deep objections to state funding of religion has to do with the possibility of state favoritism of religion. If you allow the state to fund religion, you have to worry that some religious organizations are going to be especially good at capturing that funding stream, or that there'll be collective action problems. That is, once some religious organizations come in for money, it puts a lot of pressure on other organizations to do the same. This creates some predictable dynamics, and some that were objected to even during the founding by people like Madison and Jefferson. I think we're already seeing some of those dynamics at work. after the COVID pandemic began, the federal government responded with a massive program to support religious institutions, among all kinds of other nonprofits, right? The federal government, through the Paycheck Protection Program under the CARES Act, has sent billions of dollars. The program was to the amount of something like $670 billion, sent billions of dollars to nonprofits under Trinity Lutheran and Espinoza and its understanding of this line of cases. The Small Business Administration, which was responsible for that funding, included religious organizations just like all other nonprofits. If you've got a generally available public benefit under Trinity Lutheran, under Espinoza, you can't exclude religious organizations, right? I think we've, in our history, in the nation's history, never seen direct contributions to the core mission of religious organizations in anything close to the amount of money that we have in the last 6 months. And I don't think that that money has been distributed in a neutral way. And the reason I don't think that is because, in addition to including on a neutral basis religious organizations, the SBA also granted very special exemptions to some neutral rules regarding affiliation of religious groups. And that meant that small nonprofits that were affiliated with much larger ones got special treatment because they were religious. To put a fine point on it, if you ran a religious school, but you were affiliated with a large religious organization, you could get money. But if you ran a secular school and you were small but affiliated with a large secular organization, you could not get money. And that kind of asymmetry, right, treating religion neutrally on the front end, but then granting exemptions that give it very special treatment, means that on the whole, religious groups got a lot of money when some secular groups that were similarly situated could not. And it's that kind of favoritism that I think we ought to be cautious about and on guard about. It hasn't received very much attention, but this is the inception, I think, of a new moment in our religion clause jurisprudence. And I think we ought to be attuned to this kind of structural favoritism as it's taking place. And I think that's exactly what's going on now. We've got religious institutions that want to be treated even-handedly when it comes to the distribution of public benefits, but they don't want the burdens, or at least often don't want them, and are getting exemptions that entitle them to special treatment. And it's that special treatment which has historically been objectionable, and I think is today as well. And I'll turn things over to Professor Chapman. Thanks. Look forward to your questions later.
Let me join the others in thanking Chloe and the Federalist Society. Thanks, Micah and Stephanie, for indulging me. I'm really looking forward to chatting about this further. I agree with much of what Stephanie and Micah have said. I do want to make perhaps 3 provocative claims, and at least to kickstart the question and answer period. So I'm really grateful that you did so much of the heavy lifting on the history for me, because that saves me some time. So my first claim is this. I think that the Trinity Lutheran, and then especially Espinoza, represent something that is a little different than what Professor Schwartzman suggested, although I agree with him that it's a turning point. I think the best way to understand it is that it represents a triumph of formalism in religion clause jurisprudence. And I happen to think this is generally a good thing, but I'm not so sure it was rightly done in this case. So I think this represents a long move away from the court's introduction of a functionalism that was not founded on the text or history of the Establishment Clause in the 1947 case of Everson, where the court basically just traded out the words of the clause for a requirement of separation of church and state. And as Professor Schwartzman says, he's quite right that there was general agreement among elites at the time in any way that this was a appropriate gloss on the clause. And I think historians have kind of shown that at least in the founding era and through most of the 19th century, it wasn't thought of that way at all. It was principally thought of as prohibiting a state-run church. And so the best historians on this, I think, are Donald Drakeman. Philip Hamburger's stuff is a little more confrontational perhaps, but I think Drakeman does a nice job of both the founding era history and then showing how the court, exactly how the court got the history wrong and why it got the history wrong in the mid 20th century. So there's just no textual or historical support for the court's funding cases in the late 20th century. And I agree with what Professor Barclay said about the founding era and payment of tithes, basically forced tithes. I think is principally what was going on, although I have some quibbles with Professor Storsley's argument about that. It is clear that a lot of Americans were concerned about those forced tithes because they had conscientious objections to funding other people's religious exercise, right? And they objected to that religious exercise and they thought it a form of coerced exercise. And so I think there's no doubt about that. I do think, however, education was always understood to be different, even when education was done by clergy members, and most education was done exclusively by clergy members. And so throughout the 19th century, states and the federal government both fund religiously based schools, the denominational schools in the District of Columbia, with the development of schools in the territories and in the states for Native American groups, and et cetera. So this also happened at the state level. I mentioned the federal because there may be some concern that the Establishment Clause simply didn't capture this kind of practice, but because it didn't apply to the states. But the federal government was doing it too, and there just was no peep that this violated the Establishment Clause. So the people, even like Madison and Jefferson, who were very sort of hawks about disestablishment, seem to be, not bat an eye at this kind of funding. And the reason, I think, was partly because the concern about funding clergy who are attached to a parish or funding churches had this sort of historical connotation of tithes, but especially it had this connotation of an established church. I mean, that's what an established church did in particular. And education, by contrast, was sort of a generally available good. And at least at the federal level, the programs that they ran were open to formally open to non-religious schools as well. There weren't that many that took advantage of it, again, because it was a deeply religious era. So that's a big part of the 19th century. There's no historical basis for the sort of no aid or strict separationist line. On the other hand, there's plenty of textual basis, especially for a kind of non-discrimination rule, especially non-discrimination among religious groups. Non-discrimination against religion vis-a-vis non-religion was a bit of a later arrival in the doctrine, but I think by Sherbert versus Werner, it's pretty well established. And it really Sherbert versus Werner, I think, puts the court's formal doctrine on a collision course, this tension between the Establishment Clause, no funding doctrine, and this notion that the government can't condition a benefit or a subsidy on religious exercise, right, without satisfying strict scrutiny. So that leads us to the more recent cases in Trinity Lutheran and then in Espinoza, where the court, I think, chooses a kind of formalism over a functionalism. Now, I could say it chooses accommodationism over separationism, which was, I think, the way that the battle lines were drawn in a previous generation. I'm not so sure about that. I mean, one is I don't think the court has to be accommodationist to reach the conclusions it does. It just apply a general rule of thumb that the specific governs the more general, and free exercise is generally going to trump establishment concerns unless there's a really specific history on point, I think, with this establishment. So that's a pretty formalist move, but I also think this is of a piece with generally the court's commitment to more formalism in constitutional adjudication. So and by formalism here, I'm kind of using it in the Frederick Schauer sense of text, history, and more or less trying to exclude sort of public policy functionalism as much as possible. Okay, So I think Espinoza basically represents a triumph of this movement towards a formalist approach to the religion clauses. I don't think it's over yet. I think there's certain things that the court is likely to do in this direction. For instance, the court relied on the fact that this was discrimination against religious status instead of exercise, and Justice Gorsuch called out the majority for that being atextual. We can talk about this maybe in the Q&A if you have questions about it. I have a hunch on why Roberts wanted to do that, but so in that respect, it's not totally formalistic, or formal perhaps is the best way to put that, not pejoratively. So I think this is a defensible formal decision, and I think formalism, for reasons that I can't get into here, is probably the best way to do this kind of constitutional adjudication. I don't, however, think, and this is my second provocative claim, I hope, that the text and history and precedent actually require the result in Espinoza. I think that they create a presumption against discrimination on the basis of religious exercise, but that I think there's a strong argument to be made that education should be considered a special case, either an exception to the general rule or perhaps a compelling government interest that justifies a departure or that satisfies strict scrutiny. So what was the state's alleged interest here? It was principally that they were trying to enforce disestablishment, right? They're trying to enforce separation of church and state, and the Supreme Court dismissed that concern, saying you sort of can't use a general concern about separation of church and state that is broader than what we say the Establishment Clause means to justify infringing individual free exercise rights. But I think that, in my view, the state would have been standing on firmer ground if it had relied on education as just being distinctive. So what do I mean by that? I think the sum total of our history as a nation suggests that states are free to tinker with and experiment with and to change their approach to education and the money that the government spends on education, precisely because education is a form of politics, right? It's preparation of tomorrow's decision makers for their responsibility in a Republican system of government. Education involves infusing students with intellectual, emotional, moral virtues that are necessary to propagate the polity. You're casting your vision for the future of the polity through education. Every major political philosopher has known this and written about it, right? Education is the seedbed, in other words, in a Republican system of self-governance. So this is a kind of train of thought that I don't think anybody presented to the court, certainly isn't reflected in any of the justices' opinions. But it does start to make some sense of what is often, as Professor Schwartzman says, a sordid history with respect to education and decisions about whether to fund religion or not. But it also gives it a coherence and I think a foundation in our constitutional history and tradition together, as well as normative concerns that, to me at least, is facially attractive. I want to think more about it before I really put all my money on it. So the implication of what I'm saying here, I want to be really clear. What's the doctrinal implication? I think generally the court should give states more and not less leeway to implement their vision of Republican politics through an education program. Right? So long as the program doesn't favor one form of religious exercise over another, supporting religious schools raises no Establishment Clause concerns, I don't think, historically. At the same time, the state chooses to fund only non-religious schools, whether public schools are sort of ab initio non-religious. The state wants to fund non-religious charter schools or private schools in addition. I don't think this should be understood to violate the Free Exercise Clause. So the thing that would violate the religion clauses is favoring one religious exercise over another, precisely because that is a step towards establishment. So I think that education is unique among benefits in this regard. So I don't think this kind of rationale would have to extend to other benefits and other subsidies that the government engages in, especially with various social welfare programs, whether we're talking about halfway houses, the adoption agencies and things like this, right? I think those should more or less be subject to a non-discrimination rule. So my final, I guess, provocative claim is that and Professor Schwartzman, I think, raises something that is a challenge to this, and he probably knows more about what's going on under this program than I do. But I think the practical, the end practical results of this decision are unknown. One that seems likely to me is that the court is laying itself open to the charge that it's just aggrandizing power. And this is especially the case here because this case was in a weird procedural posture when the court decided to hear it. It seemed to me to be reaching out to decide this issue, and the issue is potentially enormous, and it has the potential to eviscerate dozens of state constitutional provisions that have been around for more than 100 years, right? This is, on some definition of the word conservative, maybe a more Burkean one, this is not a conservative decision. So, it remains to be seen exactly what the result is going to be of that. And I think, if anything, it's going to galvanize separationists more than they otherwise would have been. In some respects, there was a kind of healthy political debate going on among many states at the state level about exactly how to, again, continue to tinker with the relationship between public and private schools as a sort of total package for educating the citizenry. This interfered with that in a way that seemed to load the dice for religious schools. And it's not clear to me that that is going to ultimately benefit religious schools. In other words, many states might prefer simply not to fund any private schools than to fund religious and non-religious private schools. So in any case, it also, the last thing I will add here is more, I guess, a couple of responses to what Professor Schwartzman said. So I don't disagree with his point about the sort of Protestant Catholic, coalescence after Brown. I would add only a couple points to the history that you tell, which I think is generally correct. I think part of that historically was also a response to Engel versus Vitale, where the court said no prayer in schools, in public schools. And so there was this kind of generally a growing concern about public schools. But the truth is, I think in politics, in many places, those concerns were intermingled as a political platform with concerns about desegregation. And so it's difficult historically to disentangle those. I also think the Bob Jones decision more or less puts the kibosh on there being at least a legal concern that that private religious schools are going to be able to use their government largesse to discriminate on the basis of race. Now, that case raises really important major questions that I think is actually probably where the fighting ground is going to be in the future with respect to funding and subsidy of religious schools, which is the extent to which the Bob Jones rule is going to apply to discrimination by those schools on the basis of sexual orientation or sexual conduct, that is inconsistent with the school's traditional religious norms. So I'll leave it at that, but I'm looking forward to talking more with Professor Schwartzman and Barclay and all y'all students in the cheap seats.
Wonderful. So now we're moving ahead to the Q&A session. So if you guys have questions, you can continue to submit those throughout this portion, and I'll go ahead and start reading our first questions. Okay, so the first question says, for Professor Schwartzman, I found your objection to state funding to religious groups important, but I have two related questions. A, doesn't the problem of favoritism to privileged or politically powerful actors exist in any distribution of public benefit, regardless of religious inclusion? And B, isn't the alternative to exclude religious nonprofits entirely, which also leads to an objectionable asymmetry along religious/non-religious lines?
Those are both great questions. I would say in response to the first one, and here I just have to borrow a page from some of my friends, which is that the First Amendment picks out religion for distinctive treatment, apparently. So if that's the case, and we're going to give religion distinctive treatment in that way, then We might want to worry about certain kinds of conflicts. Certainly, I think many of the framers were worried about these sorts of conflicts. They had a good reason historically to be worried about those sorts of conflicts, and so I don't find that I don't find that part of the question to be an obstacle to picking out these concerns. But I can imagine that argument being carried forward in other ways, and I've written some about it in a paper called Conscience, Speech, and Money. It's an interesting question, to what extent religion should be subject to different kinds of rules and constraints than other kinds of beliefs and practices. On the second question, I think there's a fairly straightforward answer, which is that I don't think anyone objecting to lifting accommodations or accommodations that lifted restrictions on religious organizations and nonprofits under the CARES Act was suggesting leveling down to exclude all religious organizations. When those concerns were raised, there was still $100 billion, and I don't know what the status of the fund is now, but the idea, and I think this is true in the legislative context where there are proposals that were pending over the summer in the House and Senate, is to lift the affiliation rules so that nonprofits would be treated like religious organizations that are affiliated with large national organizations. So the idea was to extend on an equal basis the same kind of funding to everyone, not to limit funding in this way. And in that sense, we just are in a post-Trinity Lutheran, now Espinoza world. If we're going to have equal funding that extends to religious organizations, okay, but once we're there, let's make sure that organizations do, in fact, get equal treatment. That's the idea.
Yeah, Professor Chapman.
Sorry, yeah, if I can just jump in. Yeah, Mike, I don't know much about those provisions, but the way you describe them makes it sound to me like they're patently wrong. So, I mean, and they don't flow from the principles articulated in Trinity Lutheran and Espinoza. So, I mean, in the sense, it's exactly what you say, right? There's no reason religious groups should get special treatment.
I mean, I think the answer here is that there's a combination of constitutional rule and RFRA. So we've got a requirement of neutral funding on the front end, and then an exemption strategy to lift restrictions that might burden both secular and religious groups. But when you only lift those burdens for religious groups, then you create a new differential. And you create an asymmetry. Now, I think the best argument for why the SBA lifted this particular set of rules is that if you didn't, then the nature of church hierarchy for some organizations, right, some religious organizations are structured so that they have small groups affiliated with large ones, would have meant that some churches would have been excluded, and that seems unfair. And I certainly understand that argument, but the result is going to be treating some religious groups in a way that's much more favorable than treating comparable secular groups. You're going to create asymmetries. I think there's a way to do it. It's what we did with a 501c3 status, which is just treat everyone the same when it comes to funding or to tax exemption. I get that. And I understand that there are powerful arguments for that. I think if we're going to be there, that's going to have to be the way the rule goes. But I'm not sure that's where we are right now. In fact, I think we're trending in a different direction.
Sure. Well, and the administrative background to the Little Sisters case in the Trump administration suggests that it knows how to level up for non-religious objectors when it wants to. So
that's right.
Okay. Our second question says, how do the parental rights found in Yoder fit into education choice here? And that's open for anyone to take.
I mean, I think that it was a litigation strategy in Espinoza that this case was brought by parent groups that wanted to focus on being able to provide those scholarships to their families. And I do think that some of the parental rights implications of Yoder and some of these other cases are interesting, in some ways more rhetorically so than with actual real doctrinal bite, I think. And Professor Schwartzman or Chapman should correct me if they think I'm wrong about that. That hasn't seemed to me to be where the rubber meets the road in the courts. Usually it's a doctrinal matter, even if they're rhetorically sort of acknowledging that that's an important piece of the puzzle of what's going on.
Great. Our next question says, it's been reported that President Trump is likely to nominate Judge Amy Coney Barrett or Judge Barbara Lagoa to fill the vacancy on the Supreme Court. Have they written on these questions, and if so, what do we know about their views? If one of them is confirmed, how do you expect they will think about these issues?
I don't know anything by Justice Lagoa, and Amy's work hasn't focused on religious liberty, to my knowledge. So if she's written about it, it certainly hasn't been in the mainstream of her writing. She writes mostly on federal courts and civil procedure. I would anticipate that she would be rather formalist about it based on her commitments in those other fields, though. And so I wouldn't be surprised if she is of a piece with the now majority on the court.
I'll just say I would expect whoever the nominee is to have a view consistent with the majority in Espinoza. It'd be quite surprising if they didn't. But of course, there are disagreements among the conservatives on the court, I think, in Espinoza about how far or how fast to move the doctrine. And I think the chief is moving more slowly than some others are prepared to go. And where the new justice is with respect to that question could matter, because there are potentially 4 votes to the right of the chief in some of these cases. And I think it could change the balance so that the chief's not in control of the direction of the doctrine anymore. That's a possibility. I'm not saying that's what will happen. I just think, it's conceivable.
Okay, the next question says, what area or type of funding is likely to be considered by the court next?
I have thoughts about that, but either of you can jump in if you want. And this goes to, because I can see the comments coming up. There's some great questions, and let me answer a couple of them at once. There's a question about, has the Supreme Court granted cert about any other religious liberty cases? What's coming down the pipeline? One of the cases that's coming down the pipeline that also has some element of government funding in it is the Supreme Court case that the court will hear this November, and that is Fulton v. City of Philadelphia. And that's dealing with the question of whether or not the free exercise clause and the speech clause are violated by a rule that would exclude Catholic Social Services, an adoption agency, from foster care if they're not willing to certify same-sex couples. And so part of the argument has been about that case. Well, this is a government program, it's a government contract, there's public funding at stake. And so if they're not willing to play by the same rules as everyone else, then they shouldn't be part of the program. The counter argument that Catholic Social Services is making is, first of all, it's not as though there is a clear rule. The government has been pretty ad hoc about this, but even bracketing that, this isn't just about funding. If Catholic Social Services can't get the government contract that operates as a license, and they can't perform the program at all, which is a burden on their religious exercise. So that's going to be an interesting case coming right up, where the court's going to be grappling with free exercise questions again in a context where public funding is at least relevant, if not necessarily the driving consideration necessarily in that case.
Can I just say, I think Professor Barclay is right that this is where the action is headed in terms of the doctrine. And Professor Chapman mentioned something similar along these lines. We're going to need to know what kinds of constraints can states and the federal government put on funding in a world where they aren't permitted to discriminate on the basis of religious status or use, even if there is a use status distinction, which is, I think, not entirely clear at this point. And Fulton is a major test of that. And so I think this is going to be an important decision. But of course, that case could come out in so many different ways, and whether the court wants to go big or small here will matter a lot to how fast we proceed into this thicket of questions about conditions on state funding. And I know there are some further questions along these lines, so I'll let you get into them.
Okay, yeah, going off that, a question says, do the panelists buy into the distinction between the funding in Locke v. Davey and that in Espinoza? And do they think the court will revisit that decision in the future?
Yeah, I thought about this quite a bit as I was preparing for tonight, because in some ways my, my theory, such as it is, really supports Locke v. Davey, but it explains why it's, the court misused it, I think, to some extent. If it's a kind of hands-off rule, in Locke versus Davey, the government had decided not to fund ministerial students in college. And if it's a hands-off rule, that should be fine. But again, the court wasn't applying a hands-off rule in Espinoza, and instead it needed to distinguish Locke versus Davey. And there's a historical distinction between, I think, funding clergy who are serving a parish and funding churches, and then on one side of the line, that being sort of generally verboten. On the other side of the line, funding education that includes religious components, a general education that includes religious components. It seems to me, even under a formal analysis, that the Locke v. Davey result was pretty sensible, and this distinction is sensible. When it comes down to brass tacks, I don't think anybody expects. I mean, the guy in Locke v. Davey is a religious liberty lawyer now, right? And so, to some extent, the whole concern of the state of Washington was misplaced. And there are a lot of people who are getting degrees in critical race theory at the University of Washington who are going to become ministers, and they're getting subsidized by the state of Washington. And there are a lot of people who are getting ministerial type degrees who are not going to last in the ministry a month, right? And so there's a bit of a mismatch there if what you're concerned about is not funding or supporting the education of a minister. But the court didn't really go into any of that in Locke versus Davey, and I didn't expect it to here.
One small thought I'll add to that, just as far as thinking about what is likely to happen. Part of the question is it likely to be revisited? Even if Locke was wrong, and I think Professor Chapman makes a lot of good arguments about why it's not, there are unique establishment clause concerns you could make arguments about related to the program in Locke v. Davey. But either way, what it seems like the court has done is really limited Locke to its facts, or a special exception to the normal rule that is now going to apply, which I think is going to be no discrimination against religious groups, certainly not based on status. Maybe outside of those unique contexts where there are real heightened establishment clause concerns like Locke present. But something interesting about the way the court handled Locke is this speaks to, I think, a broader pattern and approach of incrementalism that the Chief Justice seems inclined toward. And so with a lot of different cases, even in American Legion, we didn't see the court necessarily explicitly overruling Lemon, even though Lemon is probably all but dead letter now in most important respects. So I think that's a trend that we might see continue, and that the court is moving in different directions incrementally, isn't explicitly overruling precedents, but is cabining and limiting them. And so I do think it's unlikely that we're ever going to see the court explicitly overrule Locke, in part for that reason.
Okay, the next question says, in oral arguments for Espinoza, Breyer posed a question of whether this ruling could lead to a mandated funding of religious schools by the state, and because really we fund public schools. Is this a serious concern, or was Breyer's hypothetical far-fetched?
Breyer never has far-fetched hypotheticals, so. Micah or Nathan, you want to take this one first?
Well, I'll just ask this, which is, the Breyer hypothetical points to a problem in the underlying principle, which is, if the state is funding public education, is it also required to fund religious private education? And if it's not, what's the principle which justifies that distinction? Breyer, I think, wasn't worried so much about the politics of that. It seems highly unlikely. I mean, the private school universe is tiny compared to public schooling in our country. It would take a political revolution, I think, to shift this. But he's asking a question about what's the logic of the argument here, and how do we make sense of constraining it? And that's a nice question and a challenge, I think, for those who favor the rule. I'm not saying it can't be done. I just think that's really what Breyer was getting at.
Yeah, I agree. I actually think it's kind of a hard question, especially because the court has really hung its hat in this area, as Professor Schwartzman said earlier, on a neutrality principle. And most religious people don't consider public schools to be religiously neutral. And there's a, what counts as religious neutrality with respect to an education, which is based on a series of epistemology and metaphysics and a bunch of other things. And it's not at all clear that neutrality gets the job done. Now, I'm inclined to agree that, again, like I said earlier, the tradition suggests the state has a lot of liberty in how it crafts, how it wants to fund schools. But that's not because of neutrality as a principle. It's because of something else.
I think it's worth thinking about more. I do think it's an interesting question for reasons both Micah and Nathan are talking about. I do think that historically there have often been fairly clear distinctions about when the government is doing something itself, it has taken a service in-house versus when it has opened it up to partner with private groups. There's very different ways in which public schools operate with respect to the type of curriculum they have to offer, reporting requirements, direct control by the arm of government in a way that would raise state action issues for establishment clause concerns directly, head on, that just aren't an issue if it's a privately run school that is a lot more autonomous. It's moved, it is not a state actor. So that's not a full answer to the question. I think it's a fair question and an interesting one, but I don't think that there are, I think it's possible to come up with arguments as far as why it's certainly plausible for the government to offer services in-house that it chooses not to use private partners for, and that would be a distinction with staying if the government wanted it.
So I think I'm unpersuaded by that, Stephanie. And the reason is because this isn't just a service or a benefit that's offered in-house, it's mandatory. You have no choice. And, most students don't have financial resources to go to a non-public school. And so, there really is a root question, and, we may disagree about this, whether or not public school education is religiously neutral in the way that the court typically flings that term around, or if it's religiously neutral in the appropriate way to fling it around, which might be more likely, or if it doesn't really matter whether it's religiously neutral because the government has a freer hand in this area than we might have thought. But I don't think it does to just say that, well, this is something that the government has taken in-house. It hasn't just taken it in-house, it's forced you into the house.
Well, I mean, it's not mandatory that people have public education or even go to school. We have also seen in COVID the rise of homeschooling. So I'm not sure what you mean that it's mandatory. But
well, you have to be in school. You have no choice about that. You can go to a private school.
Homeschool, though, right?
You could, if you have a parent who's home to teach you, Stephanie. So I mean, look, there's, this is not an opportunity that's equal to everybody. And anyway, so yeah, it is possible that you can be homeschooled. It's not clear that's constitutionally protected, but probably under prevailing doctrine.
Well, but I guess it's not clear to me how the fact that people need education is relevant to the claim that there's not a meaningful distinction between when government is operating a program versus when private people are operating a program.
Well, most of the programs the government operates is not mandatory and it's not formative, right? In ways that religious people find to be religiously formative. So anyway, this is, maybe we've gone beyond where I'm ready, prepared to continue to talk about it, but it strikes me as meaningfully different from just saying we're going to give you a check, right?
Micah, any thoughts?
Look, there's an intuition that I think many conservatives have that they're being double taxed to support the public school system and then to support their private schools because they're religiously committed to them. And I think that there is a intuition around that objection, or that's within that objection grows out of an intuition that's in some tension with the idea that you can draw a clean line at the provision of of public school as a benefit. You could say something like, well, public schooling is like government speech, and as long as the government's speaking, it doesn't have to account for other interests, and it can't be objected to in various kinds of ways. Maybe that's the model. But I just think that there's, I'm not sure I see the internal logic of the stopping point. So maybe here this is not my fight particularly, but I think Nathan's gotta worry, and I think it's widely shared among many conservatives. I guess that's all I would say. I don't think there's uptake on the court. The chief is very clear, I think, in Espinoza, that the state does not have to fund private schools. And I think that line in the opinion was there precisely to mark off this debate and say, I am not interested in entertaining it.
Yeah.
But there's no argument for that, right? It's just stated.
Right, it's a non-starter.
Right.
But, you know, this is like Dranquist in Locke v. Davey. There's not much of an argument. It's just like we're going to carve this off. Or maybe there's even more of an argument in Locke than there is here. I don't know.
Yeah, I mean, I think there's more of an argument in Locke in the opinion. And I think the question is whether or not there's an argument for this rule, that public schools are different than the chief gives it. He doesn't give any argument in the opinion. But I agree with everything you're saying, Micah. I don't see any political appetite among religious liberty litigators, among sort of religious right people to just equate public and private schools and say the government has to fund whatever school somebody wants to go to, right? Interestingly, this is quite different than like the system in the UK where they have nominally an established church, but a lot of the schools that are funded by the government are religiously flavored in some respect. There are Catholic schools that you can choose to go to, or the Anglican school, or a school that is decidedly not religious. So that's a bigger question about liberalism and the requirement of funding only religiously neutral schools. That is interesting to me, because I think most of us would agree that the UK has a liberal polity.
And that makes me think of one other thing. I mean, I don't think, for the reasons you both were discussing, that there's any real threat that if a state funds exclusively public schools and doesn't want to have any other sort of private options, that then it will have to. But there is an interesting question about what about charter schools? Because I think that's different than a wholly public school in some states. It depends on how they're operated. States actually vary widely in that practice. And so it might be a fact-specific inquiry. Some charter schools look an awful lot like public or private schools. Some of them are even called community schools, and some of them look closer on the spectrum to what we envision as a fully public school. So I don't think there's a clear dividing line. I'm not pretending that there is, but I do think that there's a spectrum where there's things that look much more like clear government and things that look much more like private, and then there's harder questions in the middle.
I mean, there were charter schools that received money under the CARES Act, under the Paycheck Protection Program.
Right.
As private institutions, some of them may be religiously affiliated. I do agree with you that there is likely to be litigation over the fuzzy boundaries there. Do they count as public institutions for some purposes, not public for others? If so, what kinds of constraints can states put, what kinds of conditions? I think we'll see cases that raise all those kinds of questions.
So going quickly off, I think this can just supplement this conversation, so maybe this could be answered quickly. A question says, it seems that a lot of students who previously attended public schools have switched into religious schools during the pandemic because in many areas, religious schools are the only schools continuing with in-person instruction. What do you think are the implications of this for funding religious schools?
Nobody wants to take a shot? If you learn something from the Ryan and Jeffries history, it's that creating demand for certain kinds of education can translate into a politics. And so it can have an effect. I think really the question here is how long of one? It's expensive to send your kids frequently anyway to private schools. And when the public schools come back online, more fully. Will the children who are in those private schools, religious schools, want to stay, or will their parents pull them out and send them back to public schools? I just don't think we know the answers to those kinds of questions. As a parent, I'm in that situation myself. I don't know the answer. But I suspect there could be long-term consequences. Lots of people who probably didn't expect to have their children in private schools now do, and maybe they're committed to that going forward, and maybe they have a good experience. But I think it will, the question is, what are the long-term effects, and does exposure to different types of education translate into a politics? And I think that question just depends on how long the pandemic persists, and and how fast public institutions recover.
I also think a small, tangential question, which we were just talking about, is how many parents who have of necessity taken up homeschooling, how much of that will stick? It's interesting. I have been in that position because of COVID, and know different colleagues who have as well. So I think there's a lot of questions about how is the world going to be radically, permanently changed as a result of what we're all going through.
Okay, this question is for Professor Schwartzman. It says, you have written that Espinoza challenged your thesis about appeasement in religion cases in the Roberts Court. Could you expand on your view of the broader strategy, especially of the liberals in Espinoza and religion cases more generally?
So this is a complicated question that presumes some familiarity with an argument that I haven't laid out here. And I'm inclined partly to duck this question just for the sake of time. We've only got a couple minutes. But basically, I think that the two of the liberal justices in the court have engaged in what we call an appeasement strategy. Appeasement is a loaded term, so I want to be careful, and we are, I think, in our work on this, but that they have either joined opinions or reasoning that is not obviously consistent with some of the principles stated in other opinions. And there's a question why. Maybe they're slow playing, maybe they're trying to form more collegial relations on the court for long-term benefits. But Trinity Lutheran is a 7-2 decision with a footnote that looks like it was geared to bring justices on board who might not have otherwise joined. Espinoza is split in standard liberal conservative fashion. And we think my argument in this appeasement article is there were not gains for giving up votes in Trinity Lutheran, that the quick succession of Espinoza shows that trying to forge some consensus in the earlier case was a mistake, and that it didn't create any benefits. It obscured the dissents and for no obvious gain. That's the nature of the argument, but there's a lot behind it that I can't discuss here.
Okay, I think this might be our last question, and I think it's a good question since it's looking ahead to next term. It says, proponents of the outcomes in Espinoza and Little Sisters are optimistic about the court reversing Smith and Fulton this coming term. But if Fulton affirms Smith or comes out 4-4 with no movement in the doctrine, how will that affect the court's shift towards a laxer view of establishment?
I have some thoughts, but Nathan or Micah, you want to go first?
Can you say the last part again? How would it affect the court's shift with respect to something in establishment?
Towards, it says a more lax view of establishment.
I see. We don't know what's going to happen. I mean, that's the thing about the future, right? It's hard to predict. I think that the formalism movement that I've been describing enables the court to go back to pre-Smith if it wants to, but it certainly doesn't dictate it. I mean, there's nothing in the text or history that suggests that we need strict scrutiny as opposed to intermediate scrutiny as opposed to something else. Those are all doctrinal categories that the court is creating as proxies for what it takes to be the importance of the right. But I do think that we are going to continue to see a movement where, in cases where 20 years ago it was perceived to create a conflict between the clauses, the free exercise wins. And it's because of formalism.
So one thought I'll share, and this is relevant to an area where Professor Schwartzman and I have both written about, that is an argument that Professor Schwartzman and others have made, that the Establishment Clause should prevent religious exemption or accommodation anytime it results harm to third parties. And whether or not the court overturns Smith, we're going to know something more about their appetite for that question in this ruling, because if they grant an exemption, that means that they will show what I think has been a continuing trend of not really giving traction to that view of the Establishment Clause. I think that's a good thing for reasons I have written about elsewhere, but I think Professor Schwartzman has lots of thoughtful scholarship and commentary to the contrary. He wrote a really well done amicus brief in the Fulton case. So that's something to keep an eye out for. Is, does the court mention that theory? If they grant an accommodation, what do they say about what, if anything, the Establishment Clause says about some of those tensions where religious exemptions, like many other constitutional rights, sometimes do result in externalities for other groups?
I will say Justice Ginsburg was probably the strongest champion of that third-party harms view on the court, and she is gone. And I think that leaves Justice Sotomayor as a lone dissenter on that theory. I think that's likely. I don't know where the other liberals, Breyer and Kagan, will be on this question. It'll be interesting to see what happens there. But on the conservative side, I don't know where the chief is on Smith. And I don't know if anybody has a good prediction on this. He's had some opportunities if he wanted to show his cards. The COVID cases this summer are not super encouraging about the chief wanting to reverse Smith. The chief doesn't seem to me to like dramatic opinions of the kind that I think some religious conservatives want to see in Fulton in terms of reversing Smith. I'd expect a more incremental decision if the composition of the court had remained fixed. But if there's a justice appointed who's to the right of the chief and in favor of reversing Smith, it's not obvious that the chief's vote would control. I will say, I think the election will matter here, and we'll know, that the court will know, and the chief will know the outcome of that well before it has to decide Fulton. And I think if there is a Democratic victory in the election, it will put a lot of pressure on the court to reach narrower conclusions in these kinds of cases than they might otherwise. And of course, if Trump is reelected, I think they have much more room to work. I don't know that it will affect the outcome of the opinion. I think the politics around the opinion will shift quite dramatically depending on how the election goes.
Well, great. I think that concludes our time for this evening. Thanks so much to our panelists for giving us your time tonight, and thanks so much for our audience members for tuning in. Next Tuesday, we will have our next event with Professor Ashley Deeks, as well as Sarah Harris and Chuck Flint, on the ticking time bomb. Is TikTok a national security threat? So, nice little title we got there. Thanks so much again, panelists, and I hope everyone has a good rest of your evening.
Thanks. Great to be here.